Good afternoon. I'm Kate Reese with Reese Law. Welcome to Family Matters with Reese Law. We are a family law firm based in Fairfax and serve the Northern Virginia community as well as Southern Maryland. In episode 21 of our podcast, we will be talking with Mario Williams. He is a family law attorney who's been with the firm for quite some time and is enjoying collaborative practice and is here to talk about that today, as well as litigation and mediation settings and why one choice might be better than another choice and how some choices simply don't fit. But it is important for the client to always consider the processes that are available to them and most compatible with their desires. Hi, Mario.
Hello, Kate.
Good to see you again. And thank you for being our guest today. So first of all, tell us a little bit about yourself.
Of course. I'm Mario. I grew up in sunny Miami, Florida for a good bulk of my childhood. Attended the University of Florida for undergrad and then came up here to the DC area for law school. After passing the Virginia bar, I began working here. I've been doing family law ever since, 7 years and counting.
Excellent. Now, tell us about the collaborative process. Have you been trained in that?
I've been trained in that. The collaborative process is a particular procedure that certain family law practitioners are able to do, but in order to do that, they have to go through a particular type of training in the collaborative process before they can actually do that. I've completed that training, as have you, and it's definitely a very rewarding way of going about resolving a family law case, as opposed to the other options such as litigation or even mediation.
Mm-hmm. Now, why do you think that collaborative is a good choice?
So collaborative is one of the better choices, in my opinion, when it comes to resolving family law issues, because so many times with family law cases, you have the case, but you have everything that comes during and after the case. Just because, for example, in a divorce, a family breaks up, well, even after the divorce is final, those people are still going to be interacting with each other, especially if there are children involved, especially if there are minor children involved, because there will be graduations, there will be weddings, there will be events where they still have to be around each other. And so in the collaborative process, it's generally described as the kinder, gentler divorce. Mm-hmm. That's very important when you're going to have ongoing contact with the adversary, let's put it that way.
And that's what they're called in a litigation. They're not your spouse anymore. They're the opponent. They're the adversary. A lot of times they behave very adversarially.
Absolutely. And so really the best way to think about the collaborative process is to kind of compare it with the other options that are available. Mm-hmm. So take, for example, basic divorce. Two spouses and their marriage is ending. So with the first option, they can go and engage in litigation. Both sides file pleadings with the courts. To make their respective cases, they really have to throw all the dirty laundry out there in order to put themselves in the best position to get whatever it is they're trying to get. So that's where allegations of abuse and neglect and adultery and fault, whatever it may be, that's out there, that's in the open, and it's part of the public record. Mm-hmm. Then you have pretrial motions, exchanging information, discovery, and in the end, it's just a very unpleasant process, then let alone the trial itself, where you're testifying to these things in open court before a judge and whoever else may be in the courtroom there as well. Mm-hmm. And no one likes litigation. No one likes going through the process. It's stressful, it's unpleasant, it's not fun. Then you have mediation, where the parties go, ideally exchange information beforehand, and then they engage with a mediator, a third-party neutral, who goes and helps them facilitate communication and helps them get through whatever the issues are. So in a divorce, maybe it's custody, maybe it's support, property division, things like that. Mm-hmm. Then you have negotiation, which is just the parties directly or maybe through their attorneys. And when you go through negotiation, if the communications are productive, you can get through it that way, but if there's an impasse, maybe turn to mediation or something like that. Mm-hmm. But then you have collaborative. And with collaborative, it takes kind of the best pieces of all these different processes and uses them in a much more effective and efficient manner. So the first thing with collaborative is the parties sign a collaborative participation agreement. It's an actual contract that, among other things, states all cards are on the table. No one's going to hide assets. No one's going to hide information. Everything's going to be on the table, no hiding. Mm-hmm. Second piece of it is that it's confidential. It's private.
A lot of people really like that.
Absolutely. Why go through the process of having, for whatever reason, why the marriage in this example is falling apart, be everyone's business, where it can just be, small group.
Right. And we represent a lot of what we call 3-letter agency clients.
Of course.
Pick your agency. It's 3 letters.
Yeah, you have the agencies and anyone who may have any kind of public persona as well. Mm-hmm. And so keeping that piece private is especially important to a good number of people. So there's that piece. The other piece of it is that earlier I mentioned collaborative is the kind of gender divorce. Part of that is who consists of the team. So you have the 2 attorneys. Let me step back for a second. You have the 2 parties. Mm-hmm. They each have collaboratively trained attorneys representing them. Mm-hmm. And then what will happen is, if there are finances involved, we usually have a financial neutral. Mm-hmm. We usually have a mental health professional. And sometimes we'll have 2 mental health professionals depending on the complexity and the issues at play there.
Those are the people that are called coaches.
Correct. And the purpose of the coaches is to help facilitate communications during the collaborative process. And so they go make sure that the meetings are going forward. They help deal with some of the emotional components, because divorce is, the legal divorce, you also have the emotional divorce. It's usually very difficult for both parties. And during a divorce in general, people come to terms with that at different rates. And so that's where the coach can be especially helpful in that sense. And so the other, I mentioned efficiency a little bit earlier. The way that this is really efficient is that in litigation, engage in discovery, exchange documents, the attorney has to go through, review the financials, review the bank statements, the retirement investment, credit cards, whatever it may be. And they have to digest that and go through it that way. In the collaborative process, the financial neutral will do that. Financial neutral is usually less expensive than the attorneys. And on top of that, because all they do is finances, they can usually digest it much more quickly and then produce reports, whether it's for budgets, what's going on with certain assets like real property, houses, investment accounts, tax issues.
Retirement projections, which are often there is such a thing as the gray divorce, and that really is talking about people who are just older, over 50, getting divorced. The divorce rate continues to rise. The gray divorces have something to do with that. So we're more concerned about Social Security and retirement benefits when that's where our clients are situated at that particular time the case is happening.
Indeed. And so that's where some of those efficiencies lie. The other piece, kind of going back to the mental health professional, is, again, in a standard divorce, the attorney's the one dealing with talking with the clients, and part of that's the emotional piece. Mm-hmm. And so why have the attorney do that in the collaborative process when you have a mental health professional who is trained in this? Mm-hmm. And they're doing that at a fraction of the cost. So there's some immediate benefits in the sense that rather than the attorney wearing all of these different hats, let's put it that way, mm-hmm. each individual professional can help deal with that in a much more effective and at the same time less expensive manner.
Right. And the finance person doesn't need to know about the emotional components per se, and the parenting specialist doesn't need to know about the finances. So we're really putting an expert on each leg of the job, and they're all less expensive by the hour than the attorneys are. But one of my favorite things about neutrals is that when you have a financial neutral and they have to give some news that somebody's not going to like, that doesn't mean they get upset with the other parent. It means they get upset with the financial neutral. And then the financial neutral will walk them through and explain, this is why this means this, and make sense out of it. It still doesn't mean they'll be happy with the outcome, but it takes the heat out of the relationship between the parties, which is really nice, because that often does need to be done.
Absolutely. There's that, and not just the parties, but also the attorneys, because so commonly in litigation, the opposing party and the opposing attorney, a person will usually see them as kind of blended together because what's the opposing attorney doing? They're acting on behalf of their client. And so a lot of that animosity can get turned in that direction. Here, having it pivoted away is helpful and it helps the process move forward.
Mm-hmm. And it's interesting how the attorneys work, because if we're in a collaborative case and there's a particular legal point that's at issue and the attorneys may not agree on it, then let's just say that Mario's client raises the issue. Then it might be decided by the team that Kate's going to do the research and do a presentation on it from both sides. And so it keeps everybody involved, but also makes clear that it's a team effort and we're doing this. And Mario can say, well, and Kate's about to talk about where she and I disagree on this and why there's a divide. And then we can assess, okay, well, how does that fit our fact set? Oh, okay, well, one example is very close to our fact set. The other one has additional facts in it that don't relate, things like that. So the attorneys work together on this, and that's one of the reasons why there's a clause that says that if the case falls out, meaning somebody says, I don't want to do collaborative anymore, you do have to get new counsel, but your file gets transferred, all the notes get transferred, because you can make little agreements in between. But the new counsel will know everything. But why do you have to switch? Because we've both been in the room. We've heard everything the other person has said. It didn't all necessarily get written down, but there's an implicit bias to the fact that Kate knows all about me. She was there. So we assist clients with finding second counsel if it happens. But I've only had 2 fall out of collaborative in, I think, about 10 years. So the odds are good for the process. And the importance of the contract in the process is that is the impetus for everybody to stay in the process. It says we're going to make sure that status quo is maintained. Nobody's going to cut off the water. Nobody's going to cut off the heat. Nobody's going to take a car out of a driveway without having it discussed and agreed upon. But also on the back end, there's a plan if somebody does decide not to continue in the process.
And so you brought up falling out of collab, and I think that probably segues into a really good point, which is why not use a collaborative process? Mm-hmm. And so that first bit that you talked about falling out, which is part of the participation agreement, says that if things do fall out, then each person has to seek new counsel. And part of that is earlier when I was talking about cards being on the table, that's important because the attorney-client privilege is relaxed in the collaborative process.
It is.
And that's part of you could call it a benefit or detriment, but it's important because otherwise people are going to not want to share. If for example, in a regular negotiation, if someone says, okay, well, I want $50,000 for that, but I'm willing to take 20. Well, if you're not in a negotiation setting, an opposing attorney is going to go and run with that to court and say, well, they were willing to take $20,000 for this. Why are they asking for 50 now? Same idea in the collaborative process, which is we want the clients to be open and to be able to move forward without there being fear of, will this be using this in the future?
Right. Right.
And then the other piece, which is cost. Mm-hmm. So having all of these professionals involved at first appears a little, I hesitate to say, overwhelming in that you have 2 attorneys, financial neutral, mental health coach, and maybe others, depending on what's going on. Mm-hmm. And so at first glance, it appears like, oh my goodness, are we going to afford all of this? But when you look at collaborative compared to the other processes, in litigation, the costs are sky high. They're usually very high at the very beginning. They're usually somewhat high in the middle, depending on how many pretrial motions or discovery is going, and those types of actions. And then, of course, the trial itself is usually extremely expensive. Mm-hmm. So litigation in the long run is usually more and more expensive. Mediation, same deal in the sense that if people are not exchanging documents or information timely, then the attorneys have to step in and maybe use litigation to get that information before they can actually get into to the door of mediation.
Right. Mediation is usually not a starting point. It's a midway point. Yes. You've gotten your information together, and if you've got an opposing party who will not share, that almost pushes you into the litigation process because you can get a court order that says you have to give that up. You may not, it's my this, it's my that. Nope. Nope. You have to give us everything that we're asking for, because we are only looking at the scope of what the court can do and has to do. And there's laws that say that the court cannot divide an asset if they don't have certain information about that asset. So the attorneys have to be prepared. But the thing about the court situation is, in collaborative, you have self-determination. The parties decide, and that's really important. In mediation, you have self-determination. In the court, you are now 1/3 of the process. The other side's 1/3, and the court is 1/3. And guess who has the power? Well, you may not know what judge you're going to get, and you might have a judge that, some days I just say, okay, we're just going to have to assume that his dog got hit by a car this morning because he's in a really bad mood. Or she's had some horrible case. And so we never know. But the self-determination, yes, the judge is going to give the brown couch to the person who wants the red chair. And they're going to give the red chair to the person who wants the brown couch. And it's going to be in a court order. I once upon a time bought a client a red chair just to end it because it needed to stop. To say this is what I want the track of my future life to be, collaborative is your best place for doing that. And the other thing about the trial is when all that stuff that's in the pleadings comes out and somebody has to describe it, there may be tears, but there's also somebody who's sitting there listening to that. And your relationship as co-parents going forward, irretrievably damaged. Maybe not broken, but it's not helped. It's definitely not helped. So that's something that's unfortunate, but it's built into the legal system. It actually is. So Mario, why did you decide to become collaboratively trained? You were already out of law school. You were able to practice law. You didn't need anything else to practice.
For me, after practicing for a little bit, it became clear to me that collaborative was by far and away the best process. When you look at even regular negotiation, but more so in litigation, it's inherently vilifying and dehumanizing. It comes down to one party trying to, generally speaking, undercut, devalue, do everything that they can to shut down the other side or to minimize what's going on. Mm-hmm. And it's even having a good day in court, generally speaking, does not feel good. It doesn't feel good to the parties. It doesn't feel good, I would think, to the judges. And even as an attorney, you don't want to get up there and just tear someone apart. Whereas in the collaborative process, it's more lifting everyone up. Are there difficulties in the collaborative process? Absolutely. It is a family that is, for all intents and purposes, breaking apart, and it's turning into something different. There are difficulties associated with that, and it's not that collaborative is perfection. By no means is it perfection, but it's so much better than the alternative.
It is. It is. And a comment with regard to mediation, I said earlier that it's usually halfway through the process, but if you have all the documents and everything, you're still dealing with a neutral, which means that person is not advising you. And as a Supreme Court certified mediator, I've had people come in and they were about to make a very bad deal. And I said, we need to have your counsel in this next meeting. So sometimes people think mediation is this quick, easy thing they can do on their own. They have no advocate in the room. They don't understand what it is that the court requires or wants or what additional protections we would have you have in place that are not in the code but are regularly done in the course of family law. So mediation, I love doing it. It serves a definite purpose, but you've got to remember you don't have an advocate in that process, and you do in the collaborative law process. And so that's important. So you've been in this area of law. You're staying in this area of law. Gosh, you've given us so many examples, and we've talked about the costs and how those compare. I think, who do you think should use the collaborative process?
Realistically, I think just about everyone should use it. Not everyone, but just about everyone. There are definitely circumstances where collaborative is not a good fit. If there's a history of domestic violence, for example, probably not going to work out. Those types of power imbalances, even though the team is in place to help counter that, with something like domestic violence or situations where trust is so severed that it might not be a good fit. That's also a situation where maybe it doesn't fit. Trust is it's a bit. I say it's a bit of a spectrum.
Yes.
There, because it's one thing for say a spouse to engage in an affair.
Mm-hmm.
There you've most likely the person engaging in the affair has probably broken the trust of the other side, but okay, maybe they've broken their trust as a spouse, but not the other person's trust in as being a parent.
Right, or in financials.
Exactly.
Somebody could have a great spouse that takes care of all the finances really well, but the personal life is fractured to the point of breakup.
Exactly. But if there is still enough trust in that, those conversations can happen where maybe they're still okay from a financial perspective or from a personal perspective or a parenting perspective,
Mm-hmm.
then collaborative is still a good fit. If there is something so horrendous that has happened that there is no trust whatsoever, then collaborative is probably not a good fit, because how can a party trust anything that's coming from the other side? Or probably here's a better example. If someone has engaged in, say, financial fraud, if there's a history of falsifying financials and things like that, okay, then how do you know this tax return is legitimate? How do you know this bank statement is legitimate?
Right.
That sort of piece. So those sorts of circumstances, which are really rare, they're really, really rare.
Right.
Then okay, maybe collaborative is not a good fit. Otherwise, for the overwhelming majority of people, it's a fantastic fit. And I think most families would benefit from that compared to the other processes, because, as I said, I think in the very beginning here, for many families, they're still going to see each other going forward.
Right, right. They're going to see each other at children exchanges, and hopefully none of their children are going to have to decide which side of the church each parent will be on when it comes to a wedding or a christening, and nobody should miss out. But mostly I think that I don't think children should lose a parent because of a divorce. But if the divorce is really ugly, that can happen, possibly because one person just says, I'm walking away. I don't want to do this anymore. Or there's such animosity that it becomes so uncomfortable. They love their children, but it's not worth it because the kids are getting upset too. But isn't that the worst outcome? I mean, a child losing a parent because of the divorce, they had to when it started. So, the collaborative process is really good for supporting the family.
Yeah. So supporting the family system.
Yes.
Well, what it is the family is changing form, but the child should not lose out just because of that.
Right.
And collaborative is really the best way of preserving that in a more future-oriented approach.
Yes. Because as we remind them sometimes, you might be single, but you're still going to be a parent. And all the people who have children who come back to roost at the age of 25 or 30 know exactly what we're talking about on that one. So they're not just around for the minority. Well, thank you, Mr. Williams, for joining us today. I do appreciate your time. And I will say that, as a law firm, of course, there's a disclaimer. The material in this podcast is not offered, nor should it be construed as legal advice. The material in our podcast has been prepared and published for informational purposes only. You should not act or rely upon information contained in these materials without specifically seeking professional advice. And I will tell you that if you go to CP Nova on the web, you'll find a list of attorneys that are trained in collaborative law. And some people say, oh, yeah, I do collaborative. And then I'm like, you're not on the list. Oh, but I know how to work collaborative. I know what collaborative is. It's not the same thing. They mean they're going to be nice and friendly for a little while during the process. This is a commitment to a process that's ongoing and protects the family as much as it possibly can and works through the tough details at the same time. So please subscribe to our podcast channel so you never miss an episode. You can visit our website at reeselawoffice.com, and you can contact us at 703-279-5140. We would love to hear from you if you think that we can be of help. All three practice areas are within our bailiwick, but I will tell you that the collaborative training was a great place to find some really good tools that help us every single day, no matter what type of case it is. So we have a reputation for settling, and that includes the collaborative settlement. anything that doesn't have us in court arguing to a judge and having that third party decide how your family's going to work. So we support self-determination. Thank you.
Take care.